Good afternoon and welcome to our series of Mental Capacity Act seminars. I really hope you've enjoyed the webinars so far. All of them have been recorded, so you can pick them up as you go along. During the talk today, if you've any questions, please use the Q&A bar at the bottom of your screen. I'm delighted today to introduce Eleanor Keehan of Counsel. Eleanor is a barrister at St. John's Chambers. She's well regarded barrister in the Court of Protection. She's been involved in very complex Court of Protection cases involving fluctuating capacity and regularly acts on behalf of the protected party and the local authority. And today she's talking about recent Court of Protection cases. Please welcome Eleanor Keehan.
Thank you very much for that introduction, and thank you for inviting me to speak today. If I can just share my screen and see if we can get those slides up. I apologise, there might be a brief delay. I hope that those slides are visible to you now, and I'm sure I will be told if they are not. Thank you, as I say, for inviting me to talk. I am hoping to provide a case law update today. There have been a series of brilliant talks in this series so far, covering capacity and disclosure, JB and sexual relations, and also serious medical treatment talk is to follow. I can't improve on those brilliant talks, and so in terms of those areas, I haven't sought to include them in the case law update, and instead have looked at other areas that may be of interest. In preparing my talk, I realised that the subtitle could be "What Interesting Cases Has Mr. Justice Hayden Done This Year?" Not the official subtitle, but as you will see, very much a theme running through it. I wanted to start off today looking at cases relating to COVID-19. In what marks almost exactly a year since the first lockdown, I don't think any of us at that time would have thought that we would be in another lockdown now, or indeed that these issues would still be affecting us in a significant way and on a daily basis. Even if the primary issue in cases isn't COVID, there are a huge number of circumstances, huge number of cases where the impact of COVID-19 and the restrictions do play a large part. The cases I'm going to look at, the recent cases, are those about vaccination, about contact with persons in care homes, and also briefly touching on care provided by family members. So if I can move first to vaccinations. There are three recent cases this year in relation to COVID-19 vaccinations, and they are those on the screen. The first two were decided by Mr. Justice Hayden, and the third case was in fact heard by His Honour Judge Butler very recently, I think perhaps last week. I grouped the cases together when looking at them as, though there are of course differences in the cases, there are marked similarities between, in terms of the factual basis, but also in terms of the way the court approached these cases. Just by way of very brief background, Mrs. E and V, who was P in the second case, were both elderly women living in care homes with various types of dementia. In the latter case, CR was a 31-year-old man who had diagnoses of autism, learning disability, and epilepsy, and he was classed as vulnerable, clinically vulnerable because of this. All three cases came before the court as plans were to be put in place for the vaccine to be administered. and family members objected to that occurring. It was the children of P in the cases before Mr. Justice Hayden, and the parents and brother of P in the latter case. Turning then first to the issue of capacity. Capacity was not a significant issue in any of the cases, and indeed isn't anticipated to be in terms of COVID-19 vaccinations, as can be seen from paragraph 11 of ReUR on the screen. It's a single and entirely fact-specific issue. It's unlikely to be complex, unlikely to need overly sophisticated process, unlikely to be unable to be undertaken by experienced GPs. And indeed, it was undertaken by experienced GP in ReUR. In terms of what the relevant information is, the NHS has provided standard operating procedure, which includes the relevant information of the anticipated benefits of the vaccine, the likely side effects from the vaccine, and any individual risks they may run, and the disbenefits of not consenting. And that seems to accord with the decisions thus far. Looking then at best interests in relation to the vaccination, again, not groundbreaking new developments in terms of best interests, but interesting to note what were the issues that were accorded particular weight in terms of best interests. Of course, P's past and present wishes and feelings, belief and values. In the case of ReUR, it's noted that during the capacity assessment, Mrs. E said on a number of occasions, do whatever is best for me. What do I need to do? And that was said throughout that assessment. Mr. Justice Hayden noted that that wasn't a capacitous statement, but nevertheless reflected her autonomy. And it was important that wish, I suppose, was put forward and emphasised. There was a very useful and nice phrase that was used when considering that issue, and that is that her autonomy is not eclipsed by her dementia. And I know that that's a sentiment that we all know, but it's very helpful when it is said in such a pithy and poignant way. And so I really did like that phrase. In the case of SD involving B, P's daughter had explained that she did not think that having the vaccine would accord with her mother's previous wishes, feelings and values. However, somewhat contradictorily, and as that was noted in the judgment, the evidence of P's daughter was that P had been previously very deferential, indeed too deferential, in the past in relation to people of authority, and in particular doctors and medical professionals. And she trusted doctors implicitly and unquestioningly followed their advice previously. In terms of the views of family members, they were of course taken into account. Although there were differences between the reasons for the objections, in very broad terms, they related to questioning the efficacy of the vaccine, of the testing period over which the vaccine had been tested and the rapid testing, the risks of having the vaccine, and the fact and concerns over the vaccine not being tested on the particular cohort of people with which the court was concerned. In all the cases, but particularly in the first two cases before Mr. Justice Hayden, it was concluded that the objections by family members were authentic values held by the family members, but did reflect their values and their personality and temperament, as opposed to representing what P would have felt. In terms of the relevant circumstances, the significant risks posed to P were central in these cases, and the particular factors that led and increased that vulnerability. So that was included the age, underlying health conditions, and particular weight on the fact that these were residents of care homes, and the fact that judicial note was taken that 25% of deaths relating to COVID-19 occurred in care homes. There are also, of course, other considerations, some of which I list there. Do note one surprising element, and that was that in the case of SD, these care homes had in fact not had any cases of COVID-19. Whilst this may lead to considerations that she was at lower risk in terms of COVID-19, in fact, all persons present had now been vaccinated. There was previously very closed off in the care home. Now everyone else was vaccinated, things would be opening up, more people would be visiting, people would be going outside into the community more. And in fact, the risk was going to increase in the future. If we look then just at the issue of the risk analysis in the case, this wasn't a delicately balanced case. It wasn't finely balanced. In all three cases, there was a very clear conclusion that it was in P's best interest to have the vaccine. In SD, Mr. Justice Hayden noted that there's a strong draw towards vaccination as likely to be in the best interests. But it's important to note there that it will not always be the case, and nor even is it presumptively so. At all times, it must be an objective evaluation of what is in P's best interests. The issue of delay and the timing of applications was also raised. Mr. Justice Hayden noted that from the issue of vaccination being raised to the application coming before the court, there was a month delay, which he considered unsatisfactory. What is also important to note is that in that time, in this case, there had been an active outbreak of COVID in that intervening period at the care home. And therefore, luckily, Mrs. E didn't contract COVID-19. But obviously, the significant risks that developed or could potentially have developed because of that delay are clear. And if the matter is not capable of speedy resolution by agreement, then an application does need to be made to the Court of Protection promptly. I would just note in this respect that it is clear now that vaccinations are not considered serious medical treatment for the purposes of that procedure in the guidance. They also do not require to be heard by a Tier 3 judge, as can be seen by the most recent case. They do, therefore, when the case law is considered, it appears to be a relatively straightforward approach to vaccines. What I do note is that the cases that have currently been heard have either involved very significant risk, so real risk of death, or significant or serious illness, and the central risk factors of age, care home residents are there. It will be interesting to see if cases arise where there is that risk level is less overwhelming, and also where P's wishes, feelings, and values are not in accordance with having the vaccine, as has been in the cases thus far, and when it's perhaps demonstrably so. And so I anticipate there may be some more cases about vaccines being heard by the court in short course. Moving on then, I wanted to talk about the case of Davies and Wigan Council and the issue of restrictions on contact with people in care homes and nursing homes. This has been one of the most frequent issues being raised in the Court of Protection, but also, of course, more widely within the vulnerable members of the population and residents in care homes. The restrictions have, for many people, had a devastating effect on P and on loved ones. And I know that many here, sadly, will have been personally affected by these issues. And the impact of it really cannot be underestimated. Case of Davies and Wigan Council was a case heard by Mr. Justice Hayden in November of last year and attracted quite a bit of publicity at the time. It's important to note that in this case, the Article 10 rights and Article 8 rights of P were balanced, and indeed permission was given for P, Michelle Davies, to be named. Miss Davies' husband, who was her litigation friend, explained that she would want to be named in order for the case to be considered more widely and to hope that the litigation had a wider benefit for others. Just briefly considering the facts, this was a Section 21A challenge brought, as I say, on her behalf by her husband, a litigation friend. Mrs. Davies was a 58-year-old woman who sadly suffered with significant brain damage. Mrs. Davies was resident in a care home and had enjoyed regular and extensive contact with her family, which was sadly ended overnight by the pandemic, with only telephone contact between March and July of last year. I think this is an important case, not only on the facts, but also because three core themes, amongst others, seem to emerge from the case. And that is the importance of contact and the impact on the balance of harm, best interests analysis, the need for an individualised approach, and also the need for care homes and indeed all authorities putting restrictions on a person's contact to be proactive and to be at the forefront of the changing times. So looking at the first point, the importance of contact, again, that's phrasing, the deprivation of contact with loved ones has the potential to corrode quality of life to such a degree, it may become difficult to evaluate where the balance of harm lies, as between a risk of exposure to an insidious and life-threatening environment and compromising the most basic quality of life. I think that is, of course, a really powerful statement about just how important the issue we're dealing with here, and that it isn't clearly in all cases the risk of the coronavirus is such that it dwarfs everything else. Actually, depriving someone of that contact, of that time with a loved person, can have such significant effect. And indeed, I know that was the argument that is being run in that case, that in fact it is of such importance that best interests analysis and balance of harm is tipped. Another central and important theme is the need for an individualised approach. There is all too often a completely blanket approach that is being taken that doesn't take account of the particular needs of a person in a care home. Care home residents are not a homogenous group. They have individual needs, personalities, characters. The impact of restrictions on contact can be very different. One person, it may be utterly devastating. another person, they don't actually feel the restrictions that much, and telephone contact, WhatsApp, video contact is an adequate substitute. And so the important thing is to look at what are the needs in this particular circumstances with this particular person, and then look at what the available options to meet those needs are. Finally, then the need to be proactive. I do want to note that Mr. Justice Hayden reported very clearly and emphasised that he had seen incredible selflessness and proactiveness on behalf of care homes, and that it was really just emphasising that there is that need for care homes, as he says, to put themselves in the vanguard of the developing opportunities. And so it's just a reminder that it isn't awaiting, I suppose, awaiting guidance and waiting for guidance, but actually being at that forefront. You're likely to be aware that the Department of Health and Social Care guidance on visiting care homes has been updated, and that we now have the single nominated visitor who will undertake the rapid flow testing, use of PPE, and there should be minimal physical contact. Seems to suggest holding hands, yes, extended hugging, no. There is also being raised the essential caregiver, and this role is in exceptional circumstances where a resident would perhaps not allow a care action to take place, or become very distressed when it is undertaken by someone who is unfamiliar to them. Actually, if it's a family member, a loved one, that they would accept it and it would minimize that distress, that they should be able to provide, that family member or friend, loved one, should be able to provide that care. They would still need to undergo the same testing. They would still need to wear the same PPE as care home staff would, but they are then allowed that more physical contact. And so that is something worth exploring if you have any cases that seem to fall into that provision. Briefly then, just end of life care. It should always be permitted, even if there's an active outbreak. And it's important to emphasise that end of life is not days, hours, weeks. We are looking here at months in advance, months and weeks in advance, albeit that it is accepted that establishing that timetable can be difficult. Also to note that it doesn't mean because you've got a single nominated visitor that there's no other visits from family members, other COVID secure visits that were happening previously, screened visits, outdoor visits, pod visits, should still be able to take place. Just there's two cases here which I won't deal with in depth, but I would recommend a read. And it just, again, is re-emphasising the importance of family contact and care, particularly during this time. The first was an appeal by, these are cases, I should say, to break my run, they are for, cases heard by Mrs. Justice Leaven. The first was an appeal by the official solicitor about the construction of the coronavirus regulations. It is primarily about the legality of family members attending to provide care to P, but I think it does contain important reflections on really what the benefits of family care are, in addition to or as opposed to paid care and formal care packages, particularly in meeting emotional needs. The latter is about whether a person with terminal cancer should move from a care home to live with her daughter for her final days. Miss Justice Leaven was clear within this case that the ability to die with one's family and loved ones seems to me to be one of the most fundamental parts of any right to private or family life. And indeed, whilst Mrs. Justice Leaven was clear that this was not a case about COVID-19 in terms of balancing the public interest versus the rights of the individual, it is clear that the impact of the restrictions did have an impact on the judgment, because if P had remained at the care home, there would have been limited contact with her family around the time of her death. And that was decided ultimately not to be in her best interests. And she did, in fact, go home for her final days. Very briefly, in just looking at COVID-19 cases, we are now very used to the remote hearings that we now have to take part in. If anyone was under any illusion whether it is permitted to record proceedings if they are undertaken remotely, no, you are not. This was a case which involved excessive communication with the court office as well, and that was dealt with by a series of injunctive measures. And again, if you have any issues of these in proceedings, then this is a useful case to address those. If I then just look at the issue of domestic violence, this is a case that was heard by Mr. Justice Hayden. Sadly, the domestic violence is clearly a horrendous issue and is unfortunately now all too common with vulnerable adults and cases addressing where people have a lack of capacity. If I can briefly start on the background to this case. This case concerned a woman, LW, who was a 60-year-old woman who had a diagnosis of bipolar affective disorder. She had inpatient admissions throughout her life, but in the main part managed to achieve independent living. She was living at the time of the application at a specialist unit where she had initially been detained pursuant to the Mental Health Act. At the time of her admission, she was described as emaciated, and her personal hygiene had been entirely neglected. She was sadly in a very bad way. Mr. Justice Hayden was concerned as she had been at the unit for nearly 3 years, but the professional consensus for quite some time had been that this was no longer appropriate for her. The central challenge in this case was LW's partner, MG. MG had been living with LW at their home, and once LW had been admitted to the unit, had continued living at the home and refusing to leave. The relationship between MG and LW, the court had no doubt, even on a cursory view, that it was abusive, that it was exploitative, that it was coercive, and wholly inimical to LW's welfare. There were really shocking examples of behaviour throughout the judgment, and included restricting LW's intake of food to a salad and 1 potato a day, forcing her to say prayers and repeating prayers based on a very distorted view that MG had of religion bordering into fantasy. He forced her to smash her piano, which she got great enjoyment from playing. He forbid her from wearing underwear, which put her in compromising and humiliating situations. He was aware of the striking decline in her mental health, but did absolutely nothing to help her. He also essentially provided a script as to what she could or couldn't say to professionals. MG was therefore particularly impeding progress being made to a more independent living. He was refusing assessments taking place at the home and putting roadblocks in terms of the necessary assessments and exploration taking place. The professional view was that LW would benefit from a complete cessation of contact with MG. She was ultimately found to lack capacity in respect of contact with others and residents, and these were therefore the issues before the court. Mr. Justice Hayden considered that the issues in this case, as set out in the bottom quote, were a timely opportunity to highlight both the insidious nature of controlling and coercive behaviour, and also the extreme vulnerability of those lacking mental capacity in facets of their decision making. And it really is a welcome opportunity to review these issues, because the difficulty in these cases is that in terms extreme domestic violence can be very out in the open and easily identifiable. Controlling coercive behaviour can be a lot more difficult to identify. And as was stated within the judgment, paragraph 17, which is on the screen, it is often the cumulative effect that is important. That when one looks at a pattern of behaviour in the round, that actually this narrative of a coercive and controlling behaviour can be identified. Indeed, that is what Mr. Justice Hayden relayed in this case, that he realised that he had the benefit of the hindsight and the forensic overview of the court, and that it had taken time for the material, the events, the issues to be weaved together to see this clear picture of the abusive nature of the relationship. He was, however, remained concerned about the delay in identifying that. Within the judgment, Mr. Justice Hayden helpfully sets out guidance produced by the government in 2012 as the definitions of domestic violence, abuse, and also coercive and controlling behaviour. What I think is important to note is that it involves, as can be seen from the first quote, intimate partners or family members. There doesn't have to be that intimate couple relationship. In terms of coercive behaviour, it's important again, that issue of an act or the pattern of acts, that cumulative effect. Controlling behaviour, similarly. But also, it's important to note in terms of the controlling behaviour, the focus in the definition is not on what the act is, but on what the outcome and intention of the act is. For example, it says there, designed to make a person feel subordinate, to make them dependent upon them, to exploit them for personal gain, to deprive them of means needed for independence, resistance, escape, and to regulate everyday behaviour. It is useful to focus on what is the intention that is sought to be achieved by an act, in identifying whether there is that controlling, coercive nature of it. In the judgment, Mr. Justice Hayden also sets out some factors taking guidance from the Statutory Guidance framework published by the Home Office pursuant to Section 77 of the Serious Crime Act, as to examples of behaviour that highlight to those working with incapacitous adults and vulnerable adults, those to look out for in terms of controlling and coercive behaviour. When looking through this list, it may seem obvious, threats to hurt, threats to kill, but actually it's important to look at the fact, as I said before, that it is not always obvious, or as obvious as a threat to hurt, a threat to kill, and it is more subtle and does take a really nuanced look at circumstances. Finally, just to emphasise again, the list previously, it isn't an exhaustive list. Mr. Justice Hayden noted that it didn't include restricted food intake, which of course was an important element of this case. But again, it's this importance of the wider evidential picture. The list on the previous slide, it can provide a useful prompt sheet when looking at these issues. Say we're doing the step back, we're doing the looking at the wider picture and the cumulative effect, we're reviewing a case file, having a look at things that may have been flagged because they seemed a bit unusual, but no one could quite put their finger on it, and just look through and see, do those behaviours fall into any of these categories? And it is actually a very useful sheet to start identifying whether they're controlling a coercive behaviour is in effect in that case. It can also be used, of course, speaking to family members and seeing when they report the circumstances, do they accord with some of the issues and the examples that are raised here. I finally just note there a case of F&M, and that's a case in family court, again by Mr. Justice Hayden, where again these issues are explored in a family context and the issues reiterated. There are also, I note that it's considered there that the use of Scott schedules is not always helpful in cases of controlling or coercive control, because the nuanced analysis does not always lend itself to that formulaic approach. I also note that there were 4 conjoined appeals in the Court of Appeal in January, where the issue was considering how the family courts deal with domestic abuse and coercive and controlling behaviour. The estimated date of judgment for that, though it is only estimated, is around the end of this month. Although clearly that is in the family jurisdiction, it will certainly be capable of reading across to the Court of Protection, and I think will be very useful and interesting to those working in the Court of Protection and with vulnerable adults. If I then briefly consider the case of ReUR, and a few cases here with an international element. This was looking at the cross-border move of a Polish woman. The case was heard by, you've guessed it, Mr. Justice Hayden, and all parties agreed that it was in P's best interests to move to Poland. She'd been living in England, Polish woman living in England for some time, and it was in her best interest to return. And ultimately the court agreed. The reason why I have included this is it has the words that we would all want to hear, that the preparation and presentation of this case is a beacon of good practice, that it's a paradigm for professionals who find themselves in similar situations in the future. I have recently been looking at a case where there's a potential cross-border move, and in fact using the checklist that's provided to go through and see what we have done, what we need to do we need that element in this case, and where can that information be obtained from, was a really useful exercise in seeing whether all the ducks were in a row. And so if you have a case which involves a cross-border move, either before the Court of Protection or in planning stages, I would very much recommend having a look through this case and making reference to that checklist. The checklist is there and continues onto the second page. On the first page, it's about the professional evidence of physical health to travel, mental health to travel, the legal opinions, if any orders are needed, independent social work analysis if required, but also the more practical issues. How are they going to travel? Who's going to pay those travel costs? Are they going to have the medication they need during travel when they first arrive there? So as I say, I would recommend a read. I also note, just in respect of habitual residents and the international element, there have been two cases last year and just the year before about habitual residents, Schedule 3 and habitual residents in the Court of Protection. These cases are not new points of law developed, but they do provide very helpful summaries of the law relating to habitual residents and also then the application of that law. Again, if there are cases involving questions about habitual residents and the court's jurisdiction, these are very helpful reference cases to go to. I finally just wanted to end on some cases dealing with capacity. The first case was a case heard by His Honour Judge Dodd. And I just noted that case as His Honour Judge Dodd considered capacity in respect of 3 decisions that had not previously been addressed in reported cases. And those decision-making areas were P's ability to make decisions as to his education, to request an EHC needs assessment under Section 36(1) of the Children and Families Act 2014, and the refusal of assessment of care and support needs pursuant to Section 11 of the Care Act 2014. There is a helpful distillation within that judgment of what His Honour Judge Dodd considered was the relevant information. Of course, that will need to be amended and adapted to each individual circumstances, but of course, it's helpful guidance if any of these issues arise in cases going forward. In the case of local authority and RS, I really just wanted to highlight here the issue about risky behaviour. The local authority relied within that case on repeated risky behaviour, showing an evidence of a lack of understanding of the risk and an inability to weigh that risk. And the conclusion was that that is not necessarily so. And I feel that in a number of cases I have had, that argument has at times been put forward. And it's not as simple as that. And that risky behaviour is not inevitably evidence of a failure to understand the risk. It could mean, indeed, quite the opposite, but they've decided to take the risk anyway. 2 important factors were noted in this particular case, and that is that RS in this case had autism and a learning disability. The risk-taking behaviour was around sexual relations and meeting with other males over the internet. What the medical opinion was that, which was accepted, was that if there had been this risk-taking behaviour was as a result of the impairment, i.e. autism and learning disability, one would anticipate it to show up in other decision-making areas of RS's life, and it didn't. It was just in this one area. What was also noted was that RS was a young man, he was in his mid-20s, and that caution and consideration needed to be given to the fact that, to his maturity and to his age, and that he may just be making unwise decisions for the reason of what was termed ordinary recklessness of young people. And I thought that case had very interesting analysis about risk-taking behaviour and lack of capacity and unwise decision-making. Finally, then, it's the case of London Borough of Tower Hamlets and PB. This is an interesting case about alcohol consumption, and particularly the capacity in relation to alcohol consumption. And if you have a case that involves capacity and alcohol, I would very much recommend reading this. However, the reason I wanted to just note this case here was two reasons. One was, again, the issue of unwise decision making. And the example that was provided by Mr. Justice Hayden was the example of smoking, that clearly there are significant risks to smoking. They are plain obvious, known now. And if one was to logically put weight on the relevant factors, then nobody would smoke, but people do. And so it's important to be cautious when we're looking at the weight that is or isn't given by a person to the factors in a decision, and not to consider that just in and of itself, not appropriately weighting a factor won't lead to a conclusion that a person lacks capacity. Finally, again, just in my love of poignant phrasing, the paragraph here I thought was particularly important. That section 1(2) is the benchmark for decision makers in this sphere. To my mind, it is every bit as important as the presumption of innocence in a criminal trial. Again, looking that a person is not to be treated as unable to make a decision unless all practicable steps to help him to do so have been taken without success. The scope of these unambiguous provisions requires fully to be recognised and vigilantly guarded. And I think it is so important that whilst we all know that, to have that reminder of the central importance of these principles. Thank you very much for attending, and I hope that that talk was of some assistance. I will now try to get back to the main screen, but it may take me a little while to navigate.
Thank you so much, Eleanor. That was fantastic. And there are a lot of cases there I've not studied in any great detail. I was particularly interested in the domestic violence case in COP, because it's a very difficult area sometimes in COP, isn't it, to navigate? And the LW checklist is extremely helpful. So thank you. So all Eleanor's slides will be available to everybody after the talk. I'm just going to go to the questions now, Eleanor. So the first one is, whose responsibility would it be to bring the COVID-19 vaccination cases to COP, health or the local authority, or both? It's been both thus far. I imagine it is going to have some impact on who's funding placements, whether it's CHC or local authority responsibility, whether there's standard authorisations in place will have some impact. But I think as soon as you become aware that there is an issue here, I think that there shouldn't be too long trying to figure out which person's most appropriate, and the application should just be brought to court. I should note, in the SD case, it was in fact the daughter who had brought the case to court for a declaration that it wasn't in her best interests to have the vaccine. So there has been local authority, CCG and family member bringing the application so far. Thank you, Eleanor. And you mentioned it was a first tier judge that the application would normally go to. There's been tier 3 and tier 2 so far. I think it just, yes. Yeah. So just not needing tier 3, I think tier 3 is. Yeah. Thank you. Does the proposed use of sedation to administer a vaccine make it a serious medical treatment case? No, I don't believe it does. I would have to check, but I'm fairly confident one of the cases there was proposed use of light sedation, but there was not physical restraint. I think if physical restraint were to be used, or that there was a significant impact from the sedation, that may take it into more into the realms of serious medical treatment. But I think it would need certainly to be flagged and outlined in very explicitly within the application, but I'm not convinced it would take it to serious medical treatment. Thank you. We have had families refusing to do the rapid flow tests at the nominated as the nominated individual. This is obviously in care homes. The local authority care homes view is that these people are excluding themselves, and it's not a restriction that we are imposing upon them, as this is a requirement for them to do the rapid flow test. Would you share this view?
The DHC is guidance. So it is guidance that there should be rapid flow, lateral flow testing. I would say that there needs to be a risk assessment individualised to that person as to whether they should be able to enter the care home or not. It's not mandatory that the lateral flow testing, as I say, it's guidance. But I can understand the fact that they are refusing to do so would of course be a relevant factor in that risk analysis.
It puts the care homes in a very difficult situation, doesn't it?
Absolutely does. It absolutely does. I think it's also important that there is that dialogue of explaining why it's required and why it assists and what's involved in it, because I think it can be quite scary proposal that's going to happen. So I think keeping that open dialogue and trying to work through it as best as possible is also important.
Thank you. Next question is, I'm finding it difficult to understand an NHS trust versus XB and others, the 2020 case in EWCOP 71. Why was the matter brought to the court if there was no disagreement about the best interest basis for the treatment? Was the court hearing only about ensuring that there was an independent scrutiny of the decision in terms of autonomy?
I'm afraid it's not something I've looked at in detail, but I can come back to you perhaps on that one. I just haven't considered it in detail in this summary so far. No, it may be being covered by Lorraine, in fact, in the talk following this afternoon. So maybe the answer will be there.
Okay, that's fine. So the next question is legal aid available for people on doles if the RPR was to challenge and if the care provider have written a policy around COVID, which is really risk averse? What can we do?
Sorry, Alison, could you repeat that question?
Yeah,
again?
I think perhaps the way I phrased it is misleading, but in essence, the person, I think probably is an RPR asking if somebody is on a doles and wants to challenge on the basis, section 21A, I'm guessing on the basis that the care provider have a policy around COVID, which is just risk averse in their view.
Obviously, it's fact specific as to how far the restrictions go. Certainly that is one of the underlying themes of the Davies case was it was a challenge pursuant to section 21A because the restrictions on contact were so significant and had such a significant impact that actually it was tipping the balance on whether the best interest requirement was met as part of the standard authorisation. So, of course, whilst fact specific, in principle, yes, I think it could be bought and would therefore be entitled to the non-means tested legal aid.
Thank you, that's really helpful. So the last question I have so far is, can residents' families object to carers working with a family member if they haven't themselves had the vaccine?
Can
so family members carers object that have not had the vaccine, I'm guessing from the question.
It's not mandatory for doctors or medical professionals or carers to have the vaccine. So on that basis, I would say no. Of course, I'm sure that care homes are developing their own policy on safety. And so it may be worth considering that, but it would seem to me not on the basis that it isn't mandatory.
Those seem to be the questions thus far, but if there's anything else for Eleanor, please email me or one of the MCA team and we can get them over to Eleanor. Thank you so much for all your time today, Eleanor. Thank you for agreeing to present this. I'm very grateful. I'm sure everybody's enjoyed it. Thank you.
Thank you very much for inviting me. Thank you.
Thank you.